Good morning and welcome to the season finale of Gough Square Live. I'm Daniel Brayley and I'm joined today by the wonderful Alison Lambert, who is here to talk to us about secondary ticketing and penalty provisions under the Consumer Rights Act and other legislation. As always, Gough Square Live is broadcast live on YouTube. If you send any questions to us at goughsquarevl@gmail.com, that's goughsquarevl@gmail.com, we will deal with those questions at the end if we have time. Alternatively, you can send your questions onto our live chat on the YouTube website, which I'll be monitoring whilst Alison is speaking. So, without any further delay, I'll hand over to Alison Lambert.
Thank you, Daniel. Good morning, everyone. Could I have the first slide, please? So this morning we're going to be talking about secondary ticketing and some of the issues surrounding it and the financial penalty provisions available under the CRA. We're going to discuss what's a ticket, what are primary and secondary sellers, what the definition is under the CRA, the issues that have caused this matter to come to such attention currently in the media, and then the involvement of certain agencies such as the CMA, NTS and the ASA. So, from a practical perspective, what is a ticket? Most people will understand a ticket as the means or mechanism by which you demonstrate your entitlement to enter an event and or claim use of a particular location within an event or a seat. It might be in paper form, it might be in electronic form, for example on your smartphone. It might be a physical token or a wristband such as you'd get at a festival. From a legal standpoint, tickets, are they goods, services or digital content? Or are they a licence from the event holder to attend an event? Might this place limitations on tickets within consumer protection legislation? Well, unfortunately, this hasn't been tested in the courts yet, and none of the legislation provides any definition. So this is something where we'll have to watch this space over the months and years to come. What is a primary seller? Well, as you'll all know, a primary seller sells tickets directly from the promoter. This may be via a primary seller such as Ticketmaster, or directly by an event organiser. For instance, the RFU sell their tickets directly on their own website and they don't use any other forum by which to sell tickets. So what is secondary ticketing? Well, it's the resale of those tickets, and it is permissible by law unless there are any contractual restrictions on the ticket preventing its resale. It's not generally unlawful to purchase tickets from a primary seller in order to resell them yourself with no intention of attending the event. So the CRA definition of secondary ticketing facility means an internet-based facility for the resale of tickets for recreational, sporting or cultural events. So why does this market exist? Well, tickets for events are initially sold by primary sellers. There is some mystery around how these tickets come to be placed for sale. The mystery includes whether the tickets are on a pre-sale basis or are sold in batches on staggered release. And a purchaser might not know if a ticket is available or the tickets available are the total number of tickets available, or whether there will be some released at a later stage. And the secondary ticketing platforms exist so that tickets originally purchased from a primary seller can be resold. So who might resell a ticket? Well, there's generally three types of reseller. Firstly, an individual who purchases a ticket or tickets, subsequently finds they cannot attend an event and wants to sell the tickets on. Secondly, those who intentionally purchase tickets more than they need in order that they can sell one or two of those tickets at a profit to fund or partially fund their own purchase. And thirdly, the tickets bought by traders in bulk for the sole intention of resale. Now, there are numerous genuine fan-to-fan seller sites, and probably the best known two are Scarlet Mist and Twickets. And then there are numerous, in fact countless, reseller sites. The biggest four you'll all know: Viagogo, StubHub, Get Me In and Seatwave. Viagogo launched in 2006, Get Me In 2003 and was acquired by Ticketmaster in 2008. Seatwave launched in 2007 and that's also a Ticketmaster company since 2014. And StubHub, which is owned by eBay. So you can see straight away that Ticketmaster are a primary seller, but they also own two of the biggest of the four resellers. So what are the issues? Well, the main issue, as you'll all have seen in the media and be well aware of, is that tickets for popular events sell out extremely quickly on primary seller sites, often within seconds. And this is due in large part to traders purchasing tickets using bots or utilising bulk selling techniques. The tickets then appear almost instantaneously on secondary ticketing platforms. And this means that in effect the average consumer sitting at home will not be able to purchase from a primary seller because they simply there won't be the tickets available because they've all been snapped up by the traders. And people benefiting from these practices are obviously the primary sellers who sell all their tickets, whether they're from their primary sites or via the resale sites, and the traders who sell their tickets often at vastly inflated prices. Consumers are forced to pay for these prices if they wish to attend events because there is simply no other means by which they might obtain a ticket. The Guardian reported in May 2016 that tickets for Adele at the O2 in March 2016, with a face value of £85, were advertised on Get Me In for, wait for it, £22,000 each. And that amounted, once you'd added all the fees, to just under £25,000 a ticket. So what is happening about this issue? Well, in March 2015, the CMA obtained undertakings from the 4 main secondary ticketing platforms. The main undertakings were that information to be given would include information on restrictions on entry and the view that might apply to the ticket, information as to whether or not multiple seats listed together were in fact located together, whether there are any additional charges not included in the listed ticket price, the face value of the ticket, which might be very different, as you've just heard, from the price the ticket is available for on the secondary ticketing platform, and importantly, an email address contact for buyers to use if something goes wrong. In the same month, the CMA published an open letter to traders selling on these platforms, reminding of their obligations and pointing out that if platforms themselves prevented them from being in compliance, for example by not providing an opportunity to make a purchaser aware that they're a trader, then they should consider only using platforms which did. Following the undertakings, a further review began, and in the meantime the Consumer Rights Act and the CCRs both came into force. A review was necessary as there were clearly concerns regarding non-compliance, and these have been most notably raised directly with the CMA, the CPP Knowledge Hub and in the Waterston Review. Now, I'm sure many of you will have heard of the Waterston Review, and I'm sure some of you will have ploughed through it. It's an extremely lengthy document. And this was commissioned pursuant to Section 94 of the Consumer Rights Act. And Professor Waterston undertook an extremely comprehensive review, and it was published in May 2016. One of the issues that came from the review was a lack of understanding that was highlighted amongst consumers as to the difference between primary and secondary ticketing platforms, many believing that platforms such as Viagogo were primary sellers. And the Waterston Review recommended that the secondary ticketing platforms should ensure that they and their resellers the ones using their platforms, comply with the provisions set out in the CRA. It reminded secondary ticketing platforms that they have a legal obligation to report criminal activity, particularly fraud, on their sites. It highlighted that traders needed to be identified and that secondary sites should take more responsibility for ensuring that traders have identified themselves as such to consumers. Because, as we all know, consumers have rights against traders that extend beyond those that they have with secondary ticketing provisions of the Consumer Rights Act. It also recommended that genuine fans who were looking to just recoup the cost of a ticket they could no longer use, didn't use the big commercial reselling platforms, but instead used one of the fan-to-fan sites, as this would avoid some of the issues. Well, what this indicates is that all of these issues were already a serious and significant problem. The obvious issue with motivation for reporting criminal activity being very low is due to the fact that the object of the primary sellers is to sell all of their tickets. And likewise, secondary ticketing sites want to sell all their tickets because they have the bonus of making commission on every sale. One of the main issues that I've just touched on was the difficulty for any consumer who had a problem with any tickets they purchased from going back to the seller directly, because the vendor's details were rarely, if ever, given on a secondary ticketing site. And you only have to go online and pick any one of the main sites, apart from Get Me In, and you can't see whether you're purchasing from an individual or from a trader. On every Get Me In sale, you can see at the bottom of the first page, when you look at each individual ticket, the name of the person who's selling the ticket. December 2016, the CMA issued a press release advising of the launch of an enforcement investigation into suspected breaches of consumer protection law in the online secondary ticketing market. On the 14th of March of 2017, the CMA published their response to the Waterston Review, and they issued a press release They identified the problems, as we've already seen, but also some additional ones in that sellers weren't saying what the restrictions were on a ticket. For example, if you weren't going to be allowed access to an event because resale was prohibited. People weren't told that perhaps their ticket was in a restricted part of a venue, for example, a disabled section. It highlighted people should know who they're buying from, as we've already indicated, that's a significant problem. And pressure selling, whether claims made about the availability and popularity of tickets created a misleading impression or rushed customers into making a purchasing decision when they felt that perhaps tickets were about to sell out. Speculative selling was also highlighted as a problem, where businesses advertising tickets for sale they do not yet own and therefore may not be able to supply. And concerns about whether the organisers of some sporting events have sold tickets as a primary seller but directly through a secondary ticketing website without making this clear to consumers. And the Waterston Review recommended that a lead body such as NTS carry out a thorough review. They suggested that enforcement action in respect of breaches was tested in relation to practical scenarios, and in response to that NTS began an investigation in April 2017. The CMA confirmed in November 2017 that these practices were now being looked at by NTS, and latest guidance published under the CRA suggests that now unique ticket numbers which have started to be produced have to be on a ticket, so it's highlighting additional information that has to be given to a purchaser. In March of this year, the ASA upheld complaints against the 4 main retailers that they were misleading consumers in that prices of the tickets when they were advertised did not include all of the non-optional taxes and fees, and that they must do this in order to stop customers being misled. Could I have slide 2, please? So, as I said at the outset, I'm going to be focusing on the civil provisions under the CRA very shortly, but I just wanted to highlight that there are many criminal breaches of legislation, most pertinently under CPUTS, the Fraud Act and the Companies Act. Now, criminal breaches of legislation are apparent just by browsing the websites. If you look on any ticketing, secondary ticketing website, you will see numerous breaches glaring and jumping out at the screen. You'd be like a child on Christmas morning. Under CPUTS, we have offences that can be seen immediately: misleading actions, contravening professional diligence, misleading omissions, and banned practices under Schedule 1. The nature of these offences includes, but it's not limited to, misleading actions such as the availability of a ticket, speculative selling, as we've already identified it's a problem. Now this becomes apparent immediately when you can see on the site that there are tickets being sold that perhaps number several hundred, and yet a banner is coming up across the screen telling you that there are in fact only 25 tickets left. And it doesn't take a genius to therefore work out that people are advertising tickets which they don't have. That's also banned practice, bait advertising. There's banned practices of falsely representing yourself as a consumer, misleading information as to the identity of the trader, failing to give information as to the identity of the trader and his trading address, misleading information as to the popularity of tickets, misleading information as to the number of tickets left, omitting information affecting the ability of the purchaser to use a ticket, and omitting information as to the face value of the ticket. Now that's just a small sample that become immediately apparent when you look at how these tickets are being sold. It's also clear that under the CCR's Schedule 2, a trader must give the consumer information online as to his identity and address where he can be contacted. There's also fraud. Primary sellers impose limitations on purchasers in connection with the number of tickets they may purchase, and we'll all have seen that. It might be a limit on the number per person, it might be on the household, or it might be per credit card. Usually between 2 and 8 tickets per purchase, depending on the popularity of the event. Now, Ticketmaster's purchasing policy stipulates that ticket purchasers must be over 18 and using a credit card in their own name. It states that nothing affects the person's rights as a consumer. And all of the purchasing information, when you look at their policy, points towards the expectation that Ticketmaster is selling tickets to consumers and not traders. So when you look at sections 1 and 2 of the Fraud Act, false representations, is a fraud perpetrated on a primary seller if a purchaser uses multiple credit cards in other people's names? Well, yes. Is a fraud perpetrated on a primary seller if a purchaser uses a band of individuals all purchasing using their own credit cards, but then passing the tickets on to a trader to sell? Well, on the face of it, yes. Ticketmaster are led to believe they're selling to consumers in both cases. Now, obviously, the CPUTs don't apply to these trader-to-trader transactions, but the Fraud Act does. And there's also the provisions of fraudulent trading under Section 993 of the Companies Act of 2006. So you can see that there's a raft of criminal offending that is potentially going on here. Could I have slide 3, please? So now we're looking at the alternatives, the focus of this talk, the civil provisions under the Consumer Rights Act. And I'm going to look at the factors on deciding what penalty to impose, and also the Schedule 10 procedure that needs to be followed. And now these provisions are civil in nature, and they allow trading standards authorities to impose penalties on traders for specific breaches of the CRA. It's not all of the breaches that you might find under CPUTs, but limited ones, which we're going to come to in a second. So Section 2 of the CRA provides definitions, and I'm sure you're all going to immediately recognise the definition of trader and consumer because it's identical to that under the CPUTs. Trader, a person acting for purposes relating to that person's trade, business, craft or profession, whether acting personally or through another person acting in the trader's name or on the trader's behalf. Consumer, an individual acting for purposes that are wholly or mainly outside that individual's trade, business, craft or profession. Now, interestingly, there is a provision under Section 2.4 which states that if a trader claims that an individual was not acting for purposes wholly or mainly outside the individual's trade, business, craft or profession, they must prove it. So there's a reverse burden created there. Now you know that you have numerous powers under the CRA of investigation, powers to provide relation to production of information under Part 3 of Schedule 5, and the further powers under Part 4 of Schedule 5. Remembering the limitations imposed against self-incrimination by paragraph 17. However, there's insufficient time to go into your powers there within the constraints of this time slot, and I'd like to move on to focus on the provisions for penalties under the CRA. Chapter 5 specifically relates to secondary ticketing, and the main one to focus on today is Section 90, which is the duty to provide information about tickets. Now this applies to all sellers who resell a ticket for a recreational, sporting or cultural event in the UK through a secondary ticketing facility. Section 90 subsection 1 applies where a person, the seller, resells a ticket through the facility, and Section 90 subsection 2 says the seller and each operator of the facility, so this is now focusing on the sellers and the platforms themselves, must ensure that the person who buys the ticket is given the information specified in subsection 3, where it's applicable. And now in broad terms, the information that must be supplied is threefold. Where the ticket is for a particular seat or a standing area at the venue, information must be given necessary to enable the buyer to identify that seat or the standing area. Secondly, where there's information about restrictions which limit the use of a ticket to persons of a particular description, as I've already identified, for example, in a disabled section, it might only be accessible for wheelchair users. That information must be given. And importantly, the face value of the ticket. But of course, that will give someone the decision-making powers to whether they wish to purchase the ticket at the price it's being advertised in comparison with the face value of the ticket when it was initially sold. Now, further information included when you have to identify a seat or a location would include, for example, an area or a block within a venue where a seat is located, and a seat row or letter or number if that's applicable to that ticket. Face value is the amount stated on the ticket as its price, and there is also additional information needed to be provided to show if the seller is connected in one of 5 ways to the operator or the organiser of the event. In short, there are 5 pieces of information that need to be provided. That which is necessary to identify the location, any restriction, the face value of the ticket, details of certain connections the seller has with the online facility, and the unique ticket number if provided and if it helps identify the location. Section 91 is also a section I'm not going to focus on due to time constraints, but that is a prohibition on cancellation of tickets and blacklisting of sellers unless certain conditions apply. And section 92 is the duty to report criminal activity to the event organiser and the police. So what are your enforcement provisions? These are found at section 93. This allows a local weights and measures authority in England and Wales to impose a penalty under this section on a trader inside and outside of their area, so it's very wide. The next main point to remember is that the enforcement authority has to be satisfied on the balance of probabilities that a person has breached a duty or prohibition imposed by this chapter of the CRA, a civil burden, and then the authority may impose a financial penalty on the person in respect of the breach. There is a provision which says that if the authority is satisfied on the balance of probabilities that the breach was due to mistake, reliance on information supplied to the person by another person, act or default of another person, or an accident or another cause beyond their control, and they took all reasonable precautions and exercised all due diligence to avoid the breach, that the penalty should not be applied. Only one penalty under this section may be imposed on the same person in respect of the same breach, and the amount of the penalty must not exceed £5,000 and, interestingly, must be such as the enforcement authority imposing it determines. One very important provision to remember is that the penalty should be against the company and not against a director. So what do you consider when you're setting your penalty? There's no current guidance to assist. Comparison with penalties with letting agents is unlikely to be helpful. So a local authority is going to need to have its own policy in respect of this. And always remembering that a policy shouldn't be applied rigidly, and each case must be considered on its own merits, and policies, as always, can be subject to legal challenge. So what does one penalty for each breach mean? What if there are 3 breaches in relation to one ticket, for example 3 pieces of missing information? Does that allow for 3 penalties or 1? If 4 tickets are all sold at the same time, all containing the same breaches, is that 4 breaches, or is it 3 breaches on each ticket times 4? It seems likely that the provisions focus on a ticket, so the singular of the ticket is used in the provision. So if there are multiple pieces of information missing from one ticket, it would seem that that would be 1 breach. However, if there are then more than 1 ticket sold, arguably there would be more than 1 breach. So if you have 1 ticket, 3 breaches on 1 ticket and 4 tickets sold, it would be 4 breaches, a maximum of £20,000 penalty. The latest guidance under the CRA, published in February 2018, says that the enforcer will assess on a case-by-case basis what constitutes a breach and the appropriate size of any fine, so that's not really particularly helpful. Maximum amount of £5,000. Should the default be that £5,000 is automatically imposed in each case? This could be considered to be applying a policy rigidly. And what has to be remembered is that a person on whom you impose a penalty has a right to make representations within 28 days. A penalty has to be paid within 28 days as well. So it might be reasonable to consider how much a company is likely to be able to pay in that time, having regard to its size and its relative wealth. It's therefore clear that a local authority is going to have to consider representations made by someone on whom a penalty is imposed. What approach would the first tier be likely to take? Tribunal on appeal. One of the grounds for appeal is that the penalty applied was unreasonable, and this suggests that trading standards will have to consider what is reasonable in relation to the facts of a particular breach. I'm going to quickly move through Schedule 10, which sets out the procedure for imposing financial penalties and the appeals. Firstly, you must serve a notice of intent on the person on whom you're going to, or you're considering serving a penalty notice. You must serve it within the end of a period of 6 months, beginning on the day which the authority has sufficient evidence of the person's breach. You must set out the amount of the proposed financial penalty, the reasons for imposing the penalty, and information about the right to make representations. A person then has 28 days to make representations to the authority. At the end of that period, you must decide whether you're going to impose the penalty, and if you are, what the penalty is going to be. And you then serve a final notice on that person, setting out the amount, the reasons, information about how to pay the penalty, the period for payment, and information about rights of appeal and consequences of failure to comply. You can withdraw and amend a notice in writing, but interestingly, you can only amend it to reduce the amount specified. As mentioned, there is then an appeal to the first tier tribunal, if the person so wishes. Limited grounds that the decision to impose the penalty was based on an error of fact, decision was wrong in law, the penalty was unreasonable, or the decision was unreasonable for any other reason. And now, when the matter comes before the first tier, they may quash, confirm, or vary the notice. And any final notice must not be varied to make the penalty more than £5,000 per breach. If a person doesn't pay, or they only partially pay, there's then a procedure for civil recovery within the county courts. And very importantly, the CRA allows the enforcer to use the money for the purposes of any of its functions, whether or not the function is expressed to be a function of a local weights and measures authority. So in conclusion, if I could have slide 4, please. What are the benefits of using this power under the CRA for trading standards departments? Well, potential problems over the definition of ticket are avoided, as they do not need to be defined within the CRA. There's no criminal prosecution needed. This is a civil matter. Because it's a civil matter, there's a lower standard of proof. There's a potential for substantial recovery for numerous breaches. And trading standards get to keep the sums from those penalties. When you're looking at appeal costs, because you might be thinking, well, if we have to go to the first tier tribunal and obviously onwards to the upper tier in certain circumstances, the upper tribunal, you'll be thinking, well, we might have to face costs, a big cost bill. But the general rule in the general regulatory chamber is that there are no costs orders, save for when there's been unreasonable conduct. So you can see there in our whistle-stop overview of secondary ticketing, there's a lot to digest, and I'm now going to ask Daniel if there's been any questions.
Yes, we've had some interesting emails and comments. One question which I'd like to ask you, Alison, is this. The CMA are obviously working towards action against the Big Four, so what scope is there for trading standards to get involved?
Well, at the moment, yes, we know that NTS, the CMA, are all looking at the Big Four, and we don't yet know what the outcome of their investigations is going to be. But it may be that trading standards authorities are going to hold off until the outcome of that to see where the land lies. But once that's over, trading standards might not feel they want to tackle the Big Four, but there are literally hundreds of sellers out there of tickets on the secondary ticketing marketplace, and you only have to Google tickets for a particular event to get hundreds and hundreds of sellers up on site. So there are a lot of sellers out there who need to be looked at with these provisions.
Obviously, we've seen the draft proposals for the breaching limits on ticket sales regulations 2017. Fred in Chambers has forwarded these to me whilst we've been streaming this live.
Thank you, Fred.
Do you know when they're going to be brought into force? I'm not aware of the date at the moment.
I'm not, no. I mean, that's certainly something we can do some research on. If people would like the answer, we can send out an email.
These are an interesting set of draft regulations. What essentially they say is it can be a summary offence if someone uses any means, electronic presumably, to try and subvert a ticket limit. So where on a website it says you can only purchase 10 tickets, if someone uses a bot or something to try and purchase more than that, that can indeed be will in due course be a summary offence. In England and Wales, that person be liable to an unlimited fine. I'm not aware that when that's due to come into force. I don't think you are as well.
I'm not. No, I'm afraid I'm not aware.
But certainly we will watch this space, and as soon as we find out, we will update you accordingly. One person has asked me if you know where we can purchase Champions League final tickets from us.
Well, if you'd like to message me after, I have actually purchased them. No, no, I'm afraid I can't answer that question. But if there's no further questions, I'll hand over to Daniel to sign off.
Well, that was indeed the season finale. We are now going to take a break for spring break, but we will be back towards the end of May. So do stay in touch with our clerks, and we will notify you as to the next talk. I'd like to thank Alison for a very lively discussion there about the... Actually, I guess it wasn't so lively at the end.
Not quite so lively.
But a very interesting discussion regarding secondary tickets and the penalty provisions under the Consumer Rights Act. And thank you again for tuning in to Gough Square Live.
Goodbye to you all.
Goodbye.
I look forward to you tuning in next time.